Hey, welcome back, everyone. Thanks for joining us today for the second in our series of Erisa webinars entitled "Whose Claim Was It?" Now, back with me today are my colleagues Nancy Case in our Wisconsin office and Catherine Dowie in our Boston office. We've got some really thorny topics today. We're gonna highlight some of the toughest third-party cases that we come against, those involving minors, involving bankruptcies, and wrongful death settlements. In each of these three scenarios, we see arguments about why the plan should have no lien or that the settling parties are not bound by the plan's provisions. These are really the types of cases that keep, I think, us up at night. Is handling these types of cases. You know, second guessing, have we made the right decisions? What can we do next time to avoid some of the problems we faced in this case? And frankly, you know, when Nancy and Catherine and I were starting to put the materials together, I think I fear like we may have bit off more than we could chew in this session. I think each of these individual topics could probably last an hour, so we're going to do our best to try to touch on them and get them all within this hour for you. So I'm going to start out by addressing cases involving minors and the unique issues they pose, while highlighting some of the new case law that it's really just came out, and it's been very helpful to us. Then Catherine's going to jump in and give a primer on handling liens involving bankruptcy cases. She'll discuss the different procedures we may want to consider to enforce our lien on the funds held by a trustee. And then finally, Nancy will address the difficulties and nuances that we face when dealing with wrongful death cases. She's going to explain and highlight the importance of the underlying allocations, as well as the problematic probate exception to federal court jurisdiction. Again, if you've got questions, I will try to get them answered. There's a dashboard that you can ask questions in. They'll show up, and if we can get to them during the presentation, we will. Otherwise, we'll follow up with you afterwards about any questions you guys might have. So feel free to join in that way. But let's begin. So, I mean, in ordinary cases, we really have no issues seeking reimbursement from our participants' personal injury settlement. You know, I mean, they're injured, they receive medical care, they file a claim seeking medical expenses, and our lien attaches, right? So why is it any different when the same thing happens in cases involving children? So there's three main arguments that I want to try to cover in the section on minors. And so first of all, one of the arguments that we get are universally minors are unable to legally enter into contracts. Therefore, their attorneys argue that they cannot be bound by the terms of the plan because of lack of mutual assent. So they view the plan basically as a contract, and if a minor can't contract, then how can they be held to the obligations? We'll cover that. Second, in most states, claims for medical expenses incurred do not belong to the minor children, but to their parents. So the argument goes that no claim was made by the minors and no reimbursement is owed. Third, many states also will then require state court approval of any settlement involving a minor. So therefore, when a state court judge allocates $0 to the plan and their subrogation interest, the attorneys will, with an order in hand, will come and say, hey, no reimbursement is owed. The state court judge allocated nothing to your lien. So how do we deal with these issues? So Catherine, first, can you put up the slides?
There you go.
Awesome. So first, the first case, this Haynes case, is great, and it answers the first question that we presented. Are minors bound by the terms of the plan? The facts of this one is fairly straightforward. I know it involved a claim for medical negligence after this child went in for some gallbladder surgeries. There were some complications. But it could be any kind of factual scenario. So don't get hung up on the fact that it involved medical negligence. It could be a motor vehicle accident, slip and fall, whatever. In the case here, the minor brought and settled a medical malpractice suit against the hospital for $1.5 million. And when the plan asserted its lien, she argued that she was not bound by the terms of the plan, and she didn't sign anything. I didn't enroll in it. I didn't sign up. Therefore, because minors can't contract, her attorney argued that she wasn't bound by the terms of the plan. Naturally, the plan argued that her father's enrollment was sufficient to bind the daughter. So that was really the question presented to the court. Is her father, the plan participant, and his enrollment sufficient to bind the daughter? Next slide. So the court, rather than focusing on, state court or state law arguments about contract law, the court first turned really to what was the definition of beneficiary under Erisa. And that definition is found in 28 U.S.C. Section 102 sub 8. And basically that defines beneficiary very broadly as anyone who's eligible to receive benefits. And because there's really a statutory definition here, we don't have to go to what state law might say about what a minor's is or isn't. The question really becomes, is a beneficiary under Erisa one who's bound by the terms of the plan? And when we frame the issue that way, the court had a really easy time coming to the conclusion that first, a participant's family member is a third-party beneficiary. And under Erisa, it doesn't matter. You don't have to have personal assent. You don't have to have the minor signing up and agreeing to the terms of the plan. Frankly, you don't have to have the participant, signing on to the terms of the plan. Their enrollment and their statutory definition as a participant or a beneficiary is really sufficient enough. The court did say, hey, if she didn't want to be bound by the terms of the plan, she could have at any point refused to accept the plan's payment of benefits and paying for her medical expenses, but she didn't. So this court, and I know that the other courts have said similar things in their holdings, but the court said basically, having accepted the plan's benefits, Haynes must accept the obligations too. So the holding here is rather simple, and it kind of puts to bed a lot of these arguments that plaintiffs' lawyers use about the lack of a signed document or the fact that a minor can't contract. This is the case that you're going to want to pull out in the future anytime you're dealing with an issue about capacity to contract with minors. Next slide.
Okay, so even if a minor can be bound by the plan's terms, what if they're not allowed to pursue medical bills in their own right?
Sure. So that's fortunately, we just had this case come out. It's Virtualino versus Optum. It came out of the 8th Circuit about a month ago. One of the first, if you note the citation for those legal geeks out there, this is one of the first cases to be reported under the F4th citation, so the federal fourth reporter, whatever. If we're all lucky enough, maybe we'll make it to see the 5th reporter, but you'll now start seeing federal cases cited with the F4th citations. But anyhow, so this is a situation where we had a child injured while another child was operating an ATV back in 2013 in Nebraska. The plan paid over $600,000 of medical care. And the plan language here provided for subrogation and reimbursement. In Nebraska, the claim for medical expenses belongs to the parents. That's very common, again, in many states. And in this case, the statute of limitations period for the mother to bring suit for those medical expenses went by and expired. The plan also did not pursue a direct subrogation claim. And so later on, when the minor turned of age, the minor then sued for general damages only. So even though the statute of limitations period had passed, there's usually an exception for minors that until they turn 18, their claims don't toll. And so now when the minor turned 18, they were able to file suit. But that suit was for general damages only, and they tried to very clearly disclaim that they were suing for medical expenses. In conjunction with that third-party suit, he also filed suit against the plan. So basically filed a state court deck action that it would have no right to recover its subrogation lien from any recovery that he made in the third-party action. After the plan removed that case to federal court, the federal court adjudicated that deck action in the plan's favor, and this appeal followed. So that essentially the arguments were that, look, the claim here belongs to the mother and potentially the plan by subrogation, and the statute of limitations ran on that claim. So therefore, there would be no right of subrogation out of any recovery that the minor gets. Let's see, second, if you can advance that slide for us. Thank you. The minor also argued basically that the plan's failure to subrogate waived its later right to reimbursement. So the court is addressing a couple issues. One, does the statute of limitations running on the claim for medical expenses mean that there can be no claim? And two, somewhat related, is that does the plan's failure to subrogate mean that it then waives a later right to reimbursement? So first, the court found, similar to the court in the Seventh Circuit case that we just discussed, Haynes, that a minor as a covered person is bound by the terms of the plan. Then moving on to the more difficult question, I guess, was the plan required to subrogate? And the court, like other courts in the past, have differentiated between a plan's right to subrogation and a plan's right to reimbursement. The plans can have one, can exercise one or not. And in this case, the plan is not required to subrogate. And so while the plan may have waived its right to subrogation, it didn't waive its right to reimbursement. But then I guess on a kind of breaking that out a little bit further is, well, are those rights of subrogation and reimbursement coextensive? In other words, even though the plan's right of subrogation wasn't pursued, and that was the one that had the claim for medical expenses against the at-fault party, can a plan then later recover from potentially a general damages only suit, one that didn't expressly include medical expenses? And the court here said, no problem, because looking at the language of the plan's reimbursement provision, it is much broader than the right of subrogation. In other words, the plan has a right of reimbursement for those medical expenses out of any recovery, no matter how you characterize it or allocate it. So even if that recovery didn't technically include medical expenses, the plan's reimbursement language was broad enough to attach to that whole proceeds. And I want to give you, I guess, a little teaser alert, because this is a little bit off topic, but this is, in my view, for those of you who have been struggling dealing with reimbursement claims in Iowa based on the collateral source provision they have for medical negligence claims under Iowa Code Statute 147, 136. This case is going to be very helpful because this is within the same circuit as Iowa, and we're now going to be able to argue that under this Virtualino decision, that even if an Iowa medical malpractice suit is brought that doesn't include medical expenses, our lien is going to attach to that because the reimbursement right is broader than subrogation. So we can now kind of pivot away from arguing that Erisa preempts that code section and just argue it doesn't matter because our reimbursement rights are going to be broader than our right of subrogation. Next slide. Oh no, I'm done with my slides. You can put the slides away. But third, I want to just kind of turn to these minor settlement approval hearings. The scenario here really isn't new. The attorney for the minor will typically move to approve any settlement reached on the minor's behalf. In some cases, the attorney might invite you to appear and argue for your own allocation. In others, the attorney may actually join the plan and seek to have the lien waived. So the strategic question then you're faced with is whether to appear at that hearing or not. And if you appear, does the plan try to remove it to federal court? So I will give you this warning. The case law on removing minor settlement petitions is all over the place. To some degree, a very limited degree, courts will permit removal of such a petition, but only if the plan is first joined as a party. Second, the petition requires reference to the plan's terms. And third, they seek to extinguish the lien. So those are very, very specific. And even if you're in, the Northern District of Mississippi or the Southern District of Ohio, I'd still caution you to consider your options because it doesn't work everywhere. But I will tell you that a general petition or allocation, just a petition to allocate funds or determine subrogation rights is almost always going to be insufficient to trigger complete preemption and removal to federal court. So keep that in mind because I am, if you call me up and you say, hey, we've got this, we need you to remove it, I'm going to be very, very hesitant. I'm always hesitant about removal because if we lose, we could owe fees to the other side and it gets remanded back. I don't like that. And this is definitely one of those areas. So other options that we can consider in those situations. In some cases, we have agreed and elected at the state court minor to appear basically at the settlement hearing. Nancy, I know you've done this a number of times, right?
Yes, I have, but your caution is well taken. You really need to understand the court and the jurisdiction you're dealing with. Only if you're very familiar with the particular court that you're in would I suggest that you do that. But yes, it's been done. I have appeared on behalf of the plan, whether they've tried to be served or not served, and just explain to the court, basically, if we're not able to resolve it at this level, we'll be filing an original action, and we've been able to work it out. Oftentimes, just the threat of doing that is enough to work it out with the personal injury attorney. But yes, caution abounds in this arena for sure.
Yeah, I think maybe one of the practical pointers that we can give you is that, look, if it's a lower or medium dollar amount, it might just make sense to appear because just from a cost benefit analysis. But I think once we start getting into the six figures and up, we've got to be very careful and strategic with our decisions because my concern is always if we wander into this state court probate proceeding and we start making arguments about allocation and the judge doesn't agree with us and we get zeroed out, is that preclusive to us then later saying, yeah, we're going to go to federal court now and see what happens? It might be. So be very careful there. I think the my go-to recommendation in cases where it's worth litigating is to avoid appearing at the state court proceeding, avoid attempting to remove it. Rather, what we're going to try to do here is file a separate standalone federal court action under 502A3. So kind of that's the strategy. It was successfully employed. There's a case, I don't have it on my deck, but I can certainly share it with you. Publix versus Figaro down in Middle District of Florida last year is a good case as an example. That's the course that we generally want to take. So that kind of sums it up for the highlights on the minors cases. I feel kind of guilty that I took the easier of the three topics. But I think that between the Haynes case, the Virgilino case, and even that Figaro case that I mentioned, those three are really the arguments that we're going to have for the three most common problems that we face in minors cases. So yes, to just summarize, yes, minors are bound by the terms of the plan. 2, it doesn't matter if their settlement included medical expenses or not, as long as your plan language is broad enough, the reimbursement provision is broad enough to encompass any recovery made. And 3rd, probably going to file a standalone action under 502A3 if it's worth litigating. If not, we can sometimes jump into these minor settlement approval hearings. Without further ado now, I'm going to turn it to Catherine, and she is going to try to get you up to speed on everything bankruptcy.
Well, everything might be a little bit of a stretch. I don't know if we have enough time for that. But certainly how to deal with Erisa liens and what happens when your plan participant is in bankruptcy. So I deal with a lot of clients who, understand kind of the basics of bankruptcy that I'll get into, that there's a strong argument that when the plan has a lien, that money shouldn't be treated as belonging to the plan participant. It shouldn't be a part of the bankruptcy estate. And so I get plenty of clients who come to me and say, how do we keep this money out of the bankruptcy court? We don't want it there. The short answer is that you really can't do that. Because as a matter of federal law, settlement funds are always going to be sent to the bankruptcy court, because one of the items that belongs to the bankruptcy estate are any causes of action that the individual who's in bankruptcy might have had. So those the cause of action itself automatically becomes a part of the bankruptcy estate, and the trustee is going to get involved in those.
So Catherine, if those funds become part of the bankruptcy estate, or if that cause of action belongs to the trustee, does that mean that the funds can't be traced or aren't in control of the plan participant?
Absolutely not. So you're going to hear some language that's very familiar to all the subrogation professionals, which is that a bankruptcy trustee, for the purpose of any cause of action, including personal injury, is going to stand in the shoes of the bankrupt individual, of the debtor, for the purpose of pursuing those causes of action and for the purpose of being sued related to the cause of action. So what's going to end up happening is that the trustee is going to get the funds are going to be traceable to the bankruptcy estate, and all that's going to need to happen is that you're going to need to involve the bankruptcy trustee in any potential 502A3 action that you file. So just because the funds suddenly become a part of the bankruptcy estate by operation of federal law doesn't mean that there's no argument for arguing that the funds should not be a part of the bankruptcy estate and shouldn't be distributed to creditors of the bankruptcy estate. So there's two different ways that you can handle bankruptcy proceedings, and we'll talk about which one of these is going to be more beneficial based on the value of your case. But the theoretically proper way, the way to best assert the plan's rights as a technical matter, is to file what's called an adversary proceeding, which is literally a lawsuit that's filed in the bankruptcy court as a part of the bankruptcy. But you can assert really any kind of cause of action, including a 502A3 claim. So what most plans will do in this situation is they'll file the 502A3 claim. The debtor, so the plan participant, and the trustee, who now has control of all those funds, are going to be named as a defendant in the adversary proceeding. And under 11 USC is the bankruptcy code. So if you see 11, that usually means bankruptcy. But under section 362, a creditor is not precluded from recovering even after what's called an automatic stay. So that's kind of how the money gets into the bankruptcy and why you're not supposed to sue the debtor for money that's related to the bankruptcy, is no longer considered property of the state. By exempting the property, the debtor effectively removes property from the estate. And even though the plan is arguing that the money isn't property of the state, the court, meaning the bankruptcy court, still retains jurisdiction over the property. So they're in possession of the funds. And even though that's a matter of bankruptcy law, it lines up really well with everything to do with the Montanil case, with tracing of the funds. And so even if you could successfully file some kind of 502A3 action outside of the bankruptcy court, you might be doing yourself some harm because you're going to have tracing issues in that kind of independent action. And so even if the ultimate determination that the bankruptcy court is trying to make is whether or not the funds belong in the bankruptcy estate in the first place, they're still going to have jurisdiction to make that decision. And so you as the plan want to be involving yourself in that federal court action and not trying to create a new action or subvert the bankruptcy jurisdiction.
So, Kat, can I ask you a quick question?
Mm-hmm.
So you started with this adversary proceeding, but I feel like a lot of folks here are maybe more familiar with receiving a notice of claim form, and first and saying, well, all you got to do is fill this form out and send it back. You don't need to hire a lawyer. Just fill out the form, tell us what your lien is, and we'll consider it. Is that something that they should be doing first or should not be doing? If they receive that, is that something that should trigger a call to someone like one of us to say, what should we do?
So it should absolutely trigger you to be talking. If you're a case handler, it should be triggering you to talk to your manager, to your legal department. And certainly in a case with any kind of significant value, or even if you're not sure what the case is going to be worth, maybe the person is still treating, that should be triggering a call to your law firm, to outside counsel, to figure out what to do with the matter. Now, if ultimately you're dealing with a relatively small dollar claim, you know that the case is only going to be worth $5,000 at the end of the day, and so you know it's never going to be worth litigating. Don't let the participant's attorney tell you, well, if you're not prepared to hire outside counsel and sink all these expenses into a lawsuit, you should just go away. Because there is an opportunity for you to do exactly what Ryan just said, to fill out that notice of claim form and essentially agree to be treated as an unsecured creditor. And so what that will mean is that you may receive funds on a pro rata basis with some of the other creditors. You may ultimately receive nothing, depending on what money is put into the estate, whether or not there are secured creditors that need to be dealt with in a higher priority. But if there's a case that you're dealing with where the plan is okay waiving, okay accepting nothing, it's not going to be cost effective to hire outside counsel, the plan is still going to be able to file that notice of claim form and at least try to get whatever the bankruptcy court ultimately decides the distribution will be, without necessarily filing the adversary proceeding. The other thing to know about the proof of claim form is that you don't have to be a lawyer who's licensed to practice in the bankruptcy court in order to submit that. Individuals and even employees of companies of the interested party are able to submit those forms. Now, if there's going to be some kind of dispute over the plan's rights, if somebody tries to say that that's not a valid claim, if someone files a motion to try to get rid of the plan's interest, those are all things that you're going to need a lawyer for, and you're going to need a lawyer licensed in the appropriate jurisdiction for. But as a matter of just filing the notice of claim form, if you're prepared to walk away from that case, if the bankruptcy court awards nothing, there's not going to be a harm in filing that notice of claim form. One of the important things to do, though, is going to be to make sure that you're complying to the best of your ability with any deadlines that are set by the court and the bankruptcy trustee. And that may mean that you need to get involved in the case very early, well before there's going to be any personal injury settlement. And it may be well before you have any idea what the plan's interest is going to be. Because if the claim is being handled properly, if the bankruptcy trustee and perhaps the personal injury attorney are going to be being diligent, they're likely to notify the bankruptcy court that the plan has a potential claim, and the way they're likely to do that is to list them as a potential creditor, even though that's not technically what they are. And so if you get that notice of claim form, if you get told to submit that and don't do it timely, in accordance with the bankruptcy procedures, the risk that you run is that not only are you going to be listed as an unsecured creditor, but if you're untimely, you will only get money if there is enough to fully satisfy the claims of all the other unsecured creditors. So for example, any credit card debt that the person has. And so if you're going to go the route of simply filing the proof of claim form to see what happens, you want to do your best to comply with the bankruptcy court deadlines to make sure that you're being considered a timely unsecured creditor to give yourself the best chances of maximizing your recovery.
Okay, and if I file that proof of claim form, Catherine, am I conceding that my lien is not superior, or that I'm basically conceding I can't later do an adversary proceeding if I'm unhappy with the distribution?
Not necessarily making that concession. Certainly, one thing that we would recommend is that you do what you can to put on the proof of claim form what your client's rights are, that they have these rights under 502A3. But once you submit that proof of claim form, it's going to be more challenging for us to argue that you're not considering yourself a creditor, that you weren't subjecting yourself to the bankruptcy proceeding as a matter of being an unsecured creditor. And so if you have a case that is of more significant value, what the preferable route would be to refer that matter to outside counsel and allow us, even if we're notifying the court of something before we actually file the adversary proceeding, which we wouldn't do until there's actually a settlement fund to be had, that we're making that notification in a way that isn't simply filing the proof of claim form and consenting to be an unsecured creditor. The other thing that I'll note is that bankruptcy courts, unlike, Ryan just talked about these minors compromise proceedings. Nancy's going to talk to you about in wrongful death cases that there may be an issue of going through probate, where there are going to be state court proceedings that may not be something that the plan wants to get involved in. Going through the bankruptcy court proceeding isn't necessarily something that you should be scared of as the plan, where the bankruptcy court is going to make these equitable considerations and look to the rights of all creditors. We found that when the adversary proceedings are properly asserted, that they can actually be relatively favorable to the plan. Bankruptcy court is a federal court like any other court. You're going to get a right of appeal to a district court and then a circuit court like you would in any other case. And the adversary proceeding, because it is its own separate case within that bankruptcy proceeding, as soon as the plan's rights are determined, there's going to be an immediate right of appeal to a district court. So you don't necessarily have to wait until all the other creditors are dealt with in order to get a higher ruling if something does go wrong in the bankruptcy court. But one of the first courts to actually issue a published decision about after the McCutcheon case about whether or not a plan with proper language could pursue an entire settlement even over and above the personal injury attorney's fee was actually this bankruptcy court in the Western District of Pennsylvania, which said because the plan's lien exceeds the settlement funds, the entire settlement is not a part of the bankruptcy estate. That's going to go to the plan. They properly filed their adversary proceeding, and so we are excluding all of those funds from the assets of the bankruptcy estate. The last thing I'd say is that if you have a claim of any size, again, you should be contacting outside counsel. Bankruptcy dockets, one of the good things about them that isn't always true of state court proceedings and is definitely not true of minors proceedings, which usually aren't publicly available at all, is that bankruptcy proceedings you're going to be able to get online. All federal court dockets you're going to be able to find them through Westlaw. You'll be able to find them through Pacer. Oftentimes, if you're running some kind of assets check or even just a search for litigation at the beginning of your case, you might get flagged that there is a bankruptcy proceeding. Make a note of what that docket is and start monitoring it, because there will be updates to the bankruptcy court about settlement. The bankruptcy trustee at some point is going to have to make a motion to pay the personal injury attorney his fee for recouping the funds. And so you want to make sure that you know when that's happening so that first off, you know it's settled and you can file your 502A3 adversary proceeding. But more importantly, you want to make sure that you get those filings in there before the court approves any distribution of the settlement funds, because otherwise you do have a situation where do you need to file parallel litigation in order to trace funds that the bankruptcy court has already approved a distribution of. So you want to make sure that you're staying on top of that docket, staying on top of the right timing. And because of how accessible bankruptcy filings are, this is going to be one of the easiest cases to monitor the underlying litigation.
Well, thanks, Catherine. Wow, I feel like I know way more about bankruptcy than I did when I started. Maybe more than I want to. But Nancy, now we're going to pass the baton to you, and I feel bad that I gave you the hardest one, but hopefully you can take it and run with it. So the thorny issues of survival and wrongful death claims. What do you think? What's the recommendations?
All right. Well, you're right. There's a lot here, and when I don't know. I think I volunteered for this one. I didn't realize how much the case law had developed, and I guess that's a good thing, because that's definitely what we need to look at. But just starting at the beginning, the initial considerations is just knowing that both wrongful death and survival actions are statutory and strictly governed by state law. And like what you were talking about with minors cases and bankruptcy, that's a little bit different than what we're used to in handling these cases and getting reimbursement. So in a nutshell, wrongful death laws allow the estate to be awarded damages for the beneficiaries of the deceased. So those who suffered financially, mostly due to the deceased's death. And survival laws allow the estate to be awarded damages that the decedent could have recovered if she or he had not passed away. So pain and suffering, lost earnings. And there are several issues that are common to all states' wrongful death laws. The first issue is who can file a wrongful death lawsuit on behalf of the deceased estate. That can differ and vary from state to state, and how the person gets appointed to represent the estate. What is the mechanism for that happening? And then what types of damages are allowed in a wrongful death case. So starting with wrongful death damages, they're generally financial, and they are intended for the loss of support for all family members. But you must prove the amount of support. So minor children will receive support through the age of 18, and maybe for college if the child can prove that the deceased person would have contributed to their college education. A widow can receive loss of support until the deceased presumed retirement age, usually 65. And a widower can receive loss of support if he or she can show that the wife supported him. There are also parents or other relatives that can also receive damages for loss of support if they can prove that the deceased person supported them. So depending on the state, the deceased spouse may be entitled to receive damages for loss of consortium. There's a separate damage award for loss of the deceased services around the house. The deceased children might be entitled to damages for what is called loss of guidance and nurture. And the state may also be entitled to receive punitive damages if the defendant acted recklessly or wantonly. Also, there are damages for the deceased funeral and burial expenses, though sometimes those are damages that are under survival damages. So you should be aware that some states also have caps on wrongful death damages. So already we're moving toward allocation. There's a lot there as far as damages are to be considered. Next, survival damages. So survival laws allow the estate to be awarded damages that the deceased incurred from the moment of injury until their time of death. So they can include not only pain and suffering, but also lost earnings until his or her death. However, if the person passed away immediately as a result of the accident, then they would be entitled to pain and suffering if that can be proved, but they wouldn't be entitled to lost earnings. So moving on to notable state-by-state treatment of wrongful death claims, because that's the first thing you're going to want to look at. Where are we and what applies? So most states have two general approaches to dealing with legal issues related to wrongful death. Alabama has a third approach, and they rely exclusively on punitive damages. However, Missouri and Illinois provide examples of the two most common arrangements. They rely on recovery by survivors rather than recovery by the estate of the decedent, and that will become important to us. Kentucky, West Virginia, Connecticut, Georgia, and New Mexico, they only have one standard for losses, and that standard is the loss to the estate, regardless of who stands to inherit the estate. So New Mexico does appear to take into account losses to survivors to some extent. Tennessee, Pennsylvania, and Alaska are unique in that they have dual statutes that allow recovery by survivors of lost financial support, and recovery by the estate for loss of earning capacity. So they can be claimed under both, Pennsylvania and Tennessee, the claim can be based on loss of earnings, cannot be claimed under both acts simultaneously. So the plaintiffs must choose which act to apply. And again, that comes back around to us whenever the plaintiff gets to choose the allocation term. Most states have a wrongful death and a survival act if they have two acts. The state of Washington makes the same distinction between general survival statutes, which would typically be a wrongful death act, and its special survival act, which would typically be called a survival act. So I've been kind of alluding to this, but the most important consideration that we have in order to seek reimbursement on these cases is allocation.
So Nancy, let me ask you a question quick, because it seems like, obviously, based on the various structures of all these different state statutes, there's a lot of room for gerrymandering or shenanigans. In other words, I think the concern for our clients out there, for everyone out there, is, okay, well, if we've got a big lien and there's a good case, we may be seeing situations where, rather than pursue a claim for survival damages or any claim by the estate, if we can just pursue a pure wrongful death claim that belongs to heirs, let's bring that claim and let's not bring any claim that your lien would attach to. And are you seeing that type of a situation in your practice? And does that require us to get involved maybe earlier in a case or in a different manner?
Absolutely. I think the overall theme here is to get in early, because you definitely want to know what is happening, both on the side of the personal injury attorney, if any probate proceedings have happened, and I'll get into all of that. And again, the body of case law is growing around these issues to try to get rid of some of the shenanigans, but they definitely do occur. And it's relatively new, and New cases are cropping up, circuits are adopting different positions. So we do, we'll do best to be prepared and definitely get in early and understand exactly where you stand. So you're bringing up a very good point. So initially, talking about allocation, you always want to be thinking about what arguments you can make to steer the allocation in your direction, and you want to know what your jurisdiction courts and case law say about that. So starting with an Illinois appellate court, held that when reviewing settlements, the court should consider the percentage of the settlement allocated to the particular cause of action. So that's important. So in cases with both survival and wrongful death claims, allocation should be made according to the claim. So trying to sway everything in one direction is not going to hold, at least in Illinois. The courts will look to that, and it's an argument that you can make. So damages for conscious pain and suffering and for loss of earnings prior to death should be allocated to the survival claim, and that is the Foster v. Canary claim.
So do you view this as the plan having a voice in this allocation, or are we just watching it with, bated breath?
I think that you need to have a voice when you need to have a voice. It is going to be completely dependent on, well, I don't want to say completely, it's going to be dependent on what the personal injury attorney is planning on doing. And that will happen, relatively early on. They probably have been on notice of the lien for quite some time. And then they'll, send you a letter saying, oh, you need to waive because of, whatever their position is relative to the reimbursement. Should give you hints as to how it's going to play out. So definitely express the voice early and often when your position is in dispute. So this case, takeaway is where a plan participant is deceased, there can be no unilateral allocation of the proceeds because any settlement and allocation must be approved by the probate court. So, always the probate court. So other cases that have an impact on wrongful death and survival claims are, or is the Moore v. Blue Cross Blue Shield. It's a DC case from 1999, citing a couple of other cases from 1995 and 1997. And it states that allocation of damages in the settlement agreement, and settlement agreements are going to become important too, speaking of shenanigans, are not binding on subrogated insurer that was not a party to the agreement. So if the insurer is not a party to the agreement, it's not going to work. And the court goes on to say to hold otherwise would allow the insured and the tortfeasor to control the insurer's reimbursement rights. So there's a court that is on our side. A next important case is a Georgia case, Diamond Crystal Brands versus Wallace, where a district court allowed a plan to recover the full amount it paid in medical costs from settlement amounts that had been allocated to wrongful death claim when the settlement agreement indicated that the settlement sum was for all claims. So the settlement agreement was for all claims, even though later it was allocated in the agreement between survival and wrongful death claims. So Ryan, you have a little bit of personal knowledge about this case.
Yeah, that was one of mine. So that was a situation where obviously the plan got involved after there was already an allocation at the state court level. And what they had done is allocated everything up to the maximum that was capped under Georgia law for wrongful death, and then whatever was left over, the small amount, like 62 grand was left, they left to the estate. Now, curiously, the sole beneficiary was also the administrator of the estate, so she had all the incentive in the world to make that allocation. Now, she tried to walk that back after we filed suit and get someone else appointed as an administrator. That didn't fly so much. But the most difficult part of that case was convincing the federal court judge that he could second guess the prior allocation. We originally lost that question, so we filed our TRO, and the judge only gave us a TRO on the portion that was allocated to the estate's claim. And so we had to file a motion for reconsideration, and thankfully the judge agreed with us the second time and said, oh yeah, we can kind of look at the allocation anew, and I'm not necessarily bound by this unilateral allocation. But that's not always going to be the case, and a lot of judges will be very hesitant to second guess a state court approved allocation.
Right, agreed. So in other words, allocating the lion's share of a settlement to the wrongful death claim is an overt attempt to minimize the ERISA plan's reimbursement recovery. That's impermissible. And also, I think important within these cases where the plan prohibits the estate from doing anything to prejudice the plan's rights, including but not limited to arranging for others to receive proceeds of any judgment, award, or settlement or other payment. So again, plan terms were considered as well, and we'll get to how that becomes important. So, overall, the starting point of your analysis should begin with the Fourth Circuit. Liberty Corp versus NCNB National Bank is the first opinion in which the Fourth Circuit addressed the effect of its statute on an ERISA plan subrogation rights. So in that case, the court observed that an ERISA plan that required an insured to reimburse the plan for medical benefits did not create a subrogation right in a wrongful death claim, whereas, as in the case in Ohio, the wrongful death claim belongs to the beneficiaries and not the insured's estate. So that's an important distinction. And 1 year later, in the same circuit, in the case of McGinnis versus Provident Life and Accident, the Fourth Circuit allowed a recovery against a wrongful death settlement when the probate court order was approving a settlement that was ambiguous as to whether the settlement was for all claims or simply wrongful death claims. So you have a settlement agreement that was ambiguous. And it justified this result by holding that the settlement, unlike the Liberty settlement, comprised both survival and wrongful death claims. So if you've got an ambiguity there in the settlement agreement, pay attention to that. So in the context of wrongful death and survivorship claims, complexities abound, beginning with the benefit, the plan language. And we'll get to this toward the end, but I think you've already heard a couple of phrases. Any action that prejudices the rights of the plans and any and all recovery. You should be paying attention to that. The next important case is a 2017 case, Mackey versus Johnson. And this case was considered a coup for self-funded medical plans and a terrible precedent for the wrongful death trustees. It's an Eighth Circuit case where a sister brought a wrongful death action based on negligent treatment for lung cancer. And as part of the settlement agreement, the sister denied that the fund was entitled to any portion of the settlement proceeds. The agreement also provided that the sister acknowledged that the fund had inserted a lien, and she represented that she would satisfy the fund's subrogation rights, if any. However, she did not reimburse the fund, so the fund sued, and the fund sued her legal counsel, and the clinic under a 502A3 action, seeking a right to portion the settlement attributable to medical expenses. And the fund won its summary judgment, and she appealed. So what's interesting about this is that the sister and her counsel argued that under Minnesota statute, a wrongful death trustee cannot recover medical expenses. And the Eighth Circuit responded, that's besides the point. Although the settlement agreement was ambiguous about whether the settlement included the claim for medical expenses, so it was ambiguous, or we've got another ambiguity, other evidence was considered and supported the conclusion that the agreement included medical expenses. So what evidence is this? Well, Johnson sought damages permitted by the Minnesota statute that included medical expenses. A pre-settlement letter to the mediator asserted a large amount of damages for medical expenses. Johnson and her attorney represented to the district court that they settled the claim for medical expenses. They also acknowledged that the settlement agreement included the claim for medical expenses, but they claimed that it was settled for no money. So the takeaway here is the evidence is often there. You just have to go find it. Johnson then argued, when that was in the winner, that the fund's recovery should be limited to the expenses that were caused by the clinic's negligence. Not sure how anybody would really calculate that or figure that out, but the court completely disagreed. The court explained that under the terms of the plan, the fund, had a subrogation interest in any recovery from the clinic for medical expenses. So therefore, the fund could recover whatever Johnson recovered for the medical expenses in her settlement whether or not she could ultimately prove that she could have recovered those expenses at trial. Because that's another shenanigan. We couldn't have proved it at trial. Moving on. I think we're going to leave that there because there's a lot of it.
I just want to give everyone a warning. We're going to run over a little bit, but I want Nancy to get to this probate exception and this new case that just came out because it's going to be important. So stick with us. We'll run over time today.
Okay, sorry about that. Catherine, could you put up the slide for me, please?
Absolutely.
Disturbing trend alert. Disturbing trend alert. A preemption is being challenged by the probate exception, and it's being adopted by more and more circuits. The Fitch case is a December of 2021 case, so it didn't happen too long ago. So let's look back to where this started. Starts, of course, in New York. In the Northern District of New York in 2017 was the first we've heard of this probate exception in Re Boisseau. The probate exception was used as an exception to federal jurisdiction applied to the challenge of an Erisa plan against funds the estate had received in the settlement. So the Erisa lien dispute could not be removed to federal court. So what about this Fitch case? The Fitch versus AEP in the Eastern Division of Ohio. This case involved two interrelated motions that were before the court. And the first motion was a motion to remand by the Fitches. They wanted to remand to the Franklin County Probate Court. That's where they think this case belonged. The second motion, filed by Fitch and Fitch 2, and Fitch 2 was the federal court action filed by the fund, asked the court to dismiss the complaint in Fitch 2 because, one, it didn't fall within the court's subject matter jurisdiction. They thought it belonged with the probate court, and because it failed to sufficiently state a claim upon which relief could be granted. So the dispute seeks to resolve whether under ERISA, an employee benefit plan is entitled to reimbursement from settlement proceeds that were already allocated to various wrongful death claims in an Ohio probate court. In this case, court didn't reach that question because it found that it lacked subject matter jurisdiction over both cases before it. Embedded in Fitch 1 and Fitch 2 are two intertwined jurisdictional issues. First, the Fitches argue that the court is barred from adjudicating AEP's complaint based on the probate exception. And the probate exception is a judicially crafted caveat to federal question jurisdiction. Research it. You'll spend a lot of time on it. Separately, the administrator of the Fitch estate argued that the death action at the center of Fitch 1 is contrary to AEP's assertion, was not completely preempted by ERISA, so the probate action. So the administrator concluded that Fitch 1 can only be resolved by the Franklin County Probate Court, and the court agreed with both arguments. So its analysis started with the ERISA enforcement mechanisms. So AEP's complaint sought under 502A3 to attach two equitable liens against the settlement proceeds. One against the portion allegedly in possession of the administrator, and another against the portion allegedly obtained by the decedent's mother, Gloria Fitch. So it characterized its claim against Ms. Fitch as one that does not arise from its position as a creditor of the estate, but rather from its status as a party in contractual privity with Ms. Fitch, who, as a statutory heir of the decedent, must reimburse the plan with her portion of the settlement's proceeds. However, the Ohio probate courts are vested with plenary power to dispose fully of any matter that is properly before the court. So, having determined that both of the claims could fall into the probate court's jurisdiction, the court now had to determine whether the probate exception currently bars the court from adjudicating the fund's ERISA 502A3 action against the Fitches. So then it boiled down to whether the settlement proceeds were still within the custody and control of the probate court. And the court found that they were. And next, the court had to consider whether AEP's complaint constitutes an action in rem, and the court found that it did. It reasoned that because the plaintiffs requested relief would require the district court to dispose of property in a manner inconsistent with the state probate court distribution of assets. And went on to say that such relief was precisely what the probate exception prohibits. So again, we're running into this federal courts don't want to disturb what a state court has already decided. So that's a lot.
Yeah, so Nancy, I just want everyone to know, because I think Fitch is a big deal, that it's going to be copied certainly in Ohio, and I wouldn't be surprised if it's copied in other jurisdictions where we've got big Erisa liens, and there's obviously a probate that's open, because Fitch is saying, look, on one hand, if the plan gets sued by the representative of the estate, you can't remove it to federal court because of the probate exception. And two, even if the case ultimately the case below gets settled, the plan can't sue under 502A3 because of the probate exception. So it's really creating a potential void here where only the probate court is going to have the ability to adjudicate your Erisa lien interest. I've got some ideas about how we might be able to get around that. One of them has to obviously do with this in rem exception, in that once the probate court essentially releases jurisdiction over the estate and the fund, the settlement fund, there might be an opportunity to come back later, but then of course you're running into Montanil issues and disbursement. But the other thing that you can think about doing, and it's one we haven't done a lot in the past, is that we may have to then go into the Ohio probate court and argue for allocation there. But you've got to keep in mind there are different deadlines, and if you blow the deadlines, the probate deadlines, you could be out of luck altogether with that court. So unless this decision somehow gets corrected, and I've talked to the attorney on this case, and I don't think they're going to appeal either of these ones. I think they're going to try to go back to the probate court. They've got a really good argument, frankly, because if you go back to the facts, somehow they got $100,000 in med pay, even though they did not bring any claims for medical expenses supposedly. So I think there's some issues there, and that they didn't get proper notice and stuff like that. But this is one that everyone's going to need to watch and track, because I'm pretty sure that this is going to be contagious and spread. Anyhow, so I don't want to take more, Nancy. I know we're already over time, so I guess I just want to kind of get to the end here. Maybe if you've got recommendations about, well, what other steps should plans be thinking about when they've got wrongful death cases and they're concerned about allocations that might come up later. They're concerned that the claim for medical expenses might not even be pursued. Should we be thinking about subrogation? What do you like actual traditional subrogation? What do you think?
I think probably not. That's always a difficult route to go. But I think what you can do to ensure proper allocation is, number one, look to the plan language. How solid is it? Another idea is to get a reimbursement from the estate's representative. How about chase and pay as opposed to pay and chase? That's another consideration. You can also look to the plan terms for non-compliance. Is there an ability to request refunds if there's not cooperation from the personal injury attorney and the estate? You can, of course, consider traditional subrogation or intervention. Those are always considerations. You can always consider preemptive federal actions for declaratory relief or injunctive relief, seeking specific performance by the estate. Here's another one that's a little bit tricky, but you can try to force an ethical conflict between the estate's interest and wrongful death claimant's interests. Those are some creative ways. We can be very creative based on the facts. So I think what's really important to consider.
But these have to be flagged early. I mean, because a lot of what you're talking about is something that has to be identified early on, and certain steps taken, certain, because there's always forks in the road, right? And if we let too many of these opportunities go past, we're at the end of the case. There's been an allocation. They're in probate. Our options are pretty limited at that point.
Exactly. And you cannot sit on these cases. Once you get one of these cases, you need to take action right away, because important decisions need to be made early. You don't want to be making them on the tail end, just much more difficult at that point. You need to decide whether to pay claims or deny benefits. You need to decide whether to subrogate or intervene. And again, I think the takeaway is resting on your reimbursement rights and relying on Erisa preemption, not recommended in wrongful death and survival actions. So, I think I cut off a lot there, but there was a lot to consider.
Yeah, there's a ton there. So everybody, if you've got wrongful death questions, send them in. More specifics, the better. We can give you some more tailored advice. But it's a weedy mess. It's complicated. We'll continue to keep you aware of the cases as they come out. But before we leave today, I want to just quickly preview next month's webinar. So on Tuesday, April 26th at 12 Eastern, we'll again be walking you through this time the Form 5500 step by step. We'll also discuss issues related to the 5500, some of the guidance that has come out from the Government Accountability Office and the Department of Labor. Then we'll also touch on discussing 1024 Erisa document request and how that can be a real pain in the for plans and TPAs, and then finish up with a little bit touching on the issue of plan delivery. How do we prove it? What is plan delivery and what isn't plan delivery? So again, Tuesday, April 26th, 12 Eastern. We'll circulate invites shortly. Again, thanks everyone. Any questions? Feel free to let us know. Have a great day.